Good afternoon, Your Honor. John Simmons for Steve Paschall, accompanied by my co-counsel Beth Brooks. I'd like to reserve 3 minutes for...
Three minutes?
3 minutes, yes.
Okay.
All right, so this is a case in which Mr. Paschall is seeking his retirement benefits after his 25 years of work at Memphis Light, Gas, and Water. So as a condition of his employment, he was required to enter into and be a part of the pension plan for Memphis Light, Gas, and Water. He worked there 25 years and attained the normal retirement age. The plan itself is a government pension plan, so it's governed by Rule 401 of the Internal Revenue Code. And the respondent is the plan fiduciary under the Internal Revenue Code. Section 414G of the code makes the pension board the plan fiduciary under the code. So the basic facts are Mr. Paschall exceeded his 25 years there, and he was terminated on July the 13th, 2016. He had litigation after that with MLG&W on a claim in federal court. He lost that claim, and then when that case was over, that kind of overlapped the time of COVID. When his case was over, he sought his pension benefits. He did not have a copy of the plan itself, the plan document, in all this time frame. So he did not have access to the plan document that's now in the record, and that's under, I guess, section volume 10. So when he asked for the plan, kind of towards the end of this, and did not get it, then he applied. And when he applied, his application was rejected. And then he applied again, and that application was rejected. We've had a lot of litigation, so that at this point now we're back to he's gotten his benefits starting after his application, his first one, which was May the 10th, 2022. So the issue before the court is what happens to his approximate 6 years of retirement benefits that precede the May 10, 2022 application back to the date of his termination on July the 13th, 2016. That's the issue. So the pension board rejected that using a section of the plan called section 7.6. And 7.6 basically says that that the board is not going to make retroactive payments if, and I'm paraphrasing, but you can see the language in the section, if the retroactive payments arise because someone did not timely and properly apply. So in our case, it's very important this is a very kind of plan-intensive argument. There's something called the benefit commencement date, and it's section 1.9 of the plan, and it recognizes that your right to pension benefits can arise either by applying or under the terms of the plan, right? Well, the service retirement benefits, like Mr. Paschall's, arise under the terms of the plan. He didn't have to apply. So there's several provisions that we cite to that show this. And where I would start with the Internal Revenue Code site that I attached to the brief, it's section 401A14 of the Internal Revenue Code. It says that the plan must start the benefits on the later of three dates. And the one that would apply here is the termination date because he had already achieved the other two. It's the latter of the three. So the burden was on the fiduciary to start the benefits. And what the fiduciary did, because for whatever reason they were in litigation, the fiduciary did nothing, just sat there, and these 6 years went by and Mr. Paschall didn't know his rights. So when he eventually applies, he's told, well, hey, it's just too bad you've lost 6 years of your retirement. Now, he paid in for his retirement for 25 years, 8% of his paychecks, and they've effectively taken, by forfeiture, 6 years of his retirement. So
let me ask you a question. You say that he lost 6 years. After the time that his application was approved, and the payments began in sometime 2022, when those payments were supposed to have begun, was that not at a rate that was higher than what he would have been drawing during those 6 years anyway? So he didn't really lose that time. He just received a higher rate when he chose to, or when he, I won't use the word chose, but when he began his later payments.
It-
Is
no,
that
it's
not
a-
correct?
I don't think that's right. It's a defined pension plan, and the calculations go based upon what he made, and then it's calculated on, how long he was there. So there's a calculation. And that calculation on the amount was fixed as of July 13, 2016. So there's a block of about 6 years that he is out right now. And one of the arguments of the other side was, well, if he dies, potentially there's another calculation that could give him some more. Well, we don't know any of that. At this present time, he is out 6 years of pay, and he's not going to get that in his lifetime. Right?
So, and if I'm following your argument is that the employer or the plan must begin payments as of the date that the employee is no longer employed.
Yes, and so I attached to my brief, the Internal Revenue Code section.
Yes,
It's
you
kind of
did.
thick.
Yes, it is.
But 401, and it's A14 that says that exact thing to be.
So you're saying the employee has no control over that then? The employer has to begin benefits, period?
Well, the employee can waive that. So in the regulation I attached after that, the employee can enter into a written waiver, but it's a very specific waiver, and none of that happened. My client didn't know any of these rights. He doesn't have the document. He doesn't know any of this. Right, so, but the burden is on the fiduciary to initiate the payment. So my point of citing to 1.9, the benefit commencement date, is that it shows there are two ways to get to your benefits. And one is about operation of the plan, and we'd say the law. So to go forward, there's two sections in dispute under Section 7. It's 7.6 that they use, which has a big condition to it that you cannot, that you have to create the retroactive payment by not applying. And we're saying that doesn't apply here. We don't meet that condition because this arises under the terms of the plan and the law. There's another section right under it, 7.7, that for retirement benefits deals expressly with unclaimed benefits. And it allows people to get their unclaimed retirement benefits, just like our client, who don't apply at all. That's the point of it. It's called unclaimed benefits. That's what it means. So the use of the 7.6 basically writes 7.7 out of the plan, just like in that Matthew Long case where they had a construction of the Chattanooga pension plan that just wiped out part of the benefits. The same idea. And then there's also a term that no one will address in this, and that the benefits are non-forfeitable. He's a special category under Section 5.2 that says his are 100% vested and non-forfeitable. Well, they won't. That's a carve out of any effort to forfeit this, and no one will address that, and they won't give him the benefit of those terms of the Internal Revenue Code that imposes the obligation on the employer. So we have a kind of a list of reasons we went over in our brief of why 7.6 doesn't apply. And our point is, under the standard of review, whether it's the more favorable one that we hope remains the law with the Long case in front of the Supreme Court, or even if it changes, still the other side cannot, as the fiduciary, ignore the terms of the plan. Even under the less favorable standard of review, they can't ignore the terms of the plan and ignore the Internal Revenue Code and create a bar to my client's claims under 7.6 that effectively wipe out all the other ways to get your benefits besides filing an application. Right, so that's in a nutshell is our argument that Mr. Paschall was not required to apply. It was the burden, and I got the Internal Revenue Code site, which dovetails in with the definitions in the plan and the benefit commencement date. And then there's also a provision in 6.1A1 that deals with payment of service retirement benefits, and it uses mandatory language. They shall be paid. It's not the may. If you look in 6.1A1 about service retirement benefits, it shall be paid, and it's a lifetime annuity for the participant. So our argument is, when you add all this up and you look at what the Internal Revenue Code clearly says in 401A14, it was their burden to start the benefits. Our client didn't know any of this. He didn't have the plan, and a fiduciary cannot sit there and then later reconstrue the terms of the plan to just bar him and ignore all these other provisions that are never accepted. And I just want to draw the court's attention to the word non-forfeitable. His benefits, not all benefits, his benefits are non-forfeitable under 5.2. The other side's argument was, well, that's just the calculation. Well, the calculation is in 4.1. If you read 4.1, it talks about the monthly payments for the remainder of your life. It's not just the calculation, it's the benefits. Those benefits are 100% vested and non-forfeitable for our client because he was there for more than 25 years. He attained the normal retirement age before he was terminated. So the word non-forfeitable, there's just no way around that word, and it's never been addressed, right? In the context of the Internal Revenue Code, all these sections, it also says you can't forfeit it, and that's really clear. So whatever 7.6 said, it carves out non-forfeitable because the obligation to pay doesn't arise because he didn't apply. It was non-forfeitable, and it was their burden to pay it after all. So our argument is that fails under this arbitrary and capricious, unwarranted exercise of discretion. Then we have the additional piece, and they make the same argument. He had the burden to apply, and that's not the plan language. That would fail the evidence test under H5 of the substantial material evidence, because what they say he had the burden to do, he just didn't have the burden to do. Then our other now, and I want to point out on the statute on deference. Remember, we have statutory issues here, and in 3, the statute under H1, 2, and 3, those deal with statutory claims and rights. There's no discretionary language there. The pension board doesn't have the power to change the law. The court gets to decide what the law is. So there's no basis for deference on what the Internal Revenue Code says and what these governing provisions apply. And then I guess my last argument was the process was constitutionally deficient. I lay those facts out in my brief, but we really didn't we got 20 minutes. We have no evidentiary hearing. People are commenting on him. We don't know who they are. We have no right of cross-examination. The same lawyer that denies it is the advocate and writes the opinion. It's just a constitutionally deficient process that we've had to go through to get here. And I believe under that Morrell case and the Sizemore case, it wasn't constitutionally acceptable. And so that's another ground under H3 where it has unlawful method or whatever for overturning this as well. So we'd ask for his benefits back to 2016, the day after he was fired, cost of living adjustments, and I believe we're entitled to prejudgment interest and attorney's fees for the deficient process. Thank you.
Thank you.
Good afternoon, Your Honors. Tom Henderson for the respondents. The petitioner was terminated from employment in 2016. At that time, he could have applied for retirement benefits. He was eligible, he was vested. But strategically, he intentionally decided not to apply for benefits at that time because he felt it would have adversely affected another lawsuit he had against MLGW. 6 years later, he first applies for benefits, claiming benefits retroactive to the date of his termination. But Section 7.6 of the plan plainly states that retroactive benefits will not be paid. Based on Section 7.6, the pension board and the court below both ruled against the plaintiff petitioner, saying he was not entitled to retroactive benefits. And this court should affirm. First, the board and the Chancery Court reached the correct decision, giving honest and due consideration to all the evidence in front of it. Because of that, this court doesn't even need to address the arbitrary and capricious argument under Starlink, which we cited in our brief. Second, if the court does reach the arbitrary and capricious standard, the decision was not arbitrary and capricious. First, it cannot be arbitrary and capricious to apply plain language of the plan to the case. Second, there was sufficient and material evidence in support of the decision. There was no clear error made by the board or the court. And when you look at it, the petitioner's, quote, operation of the plan, close quote, argument fails quickly on at least 5 bases, and we'll cover that. Third, or next, you can't construe the plan, as he asserts, to contradict plain terms of the plan using an inapplicable plan section. You can't do that. Finally, there was no violation of any law, no violation of any improper procedure or anything like that.
He places a lot of emphasis on the IRS. What do you have to say about that?
Both the statute and the regulation, Section 401A14 states, quote, unless the participant otherwise elects. Okay, that's the code section. The regulation, 26 CFR 1.401A14, states, quote, notwithstanding the preceding sentence, a plan may require that a participant file a claim for benefits before payment of benefits will commence. So both the statute and the regulations say you can require a participant to elect benefits. It doesn't say they must be paid at the date of termination. It says if the participant can be required to elect to begin retirement benefits, which is exactly what the petitioner did here. He elected not to receive them back in 2016. Now, as far as the facts, basically undisputed. Again, he didn't apply. At the board hearing, proof was introduced that others had applied for retroactive benefits before and none got them, and that's in the record at 249. Section 7.6 says, and I quote, each participant and beneficiary or his or her representative shall be responsible for making application. Consistent with the statute and the regulation, the plan says you must make an election. And then it says, and I quote again, a participant or beneficiary shall have no claim against the fund for any retroactive payment by reason of the failure of such participant or beneficiary to properly or timely apply for benefits under the plan. Section 7.6, it's clear, it's unambiguous, it requires an election, and it says no retroactive payments will be made. That's the end of the case. That is not arbitrary and capricious. That means the board got it right. But also at the hearing before the board, there was no proof that anyone ever got benefits, quote, by operation of the plan. There was no proof that anyone ever got benefits without applying for them. The record before the board was undisputed and before the Chancery Court that you have to comply with Section 7.6. Now, petitioner's, quote, operation of the plan, as was asked, he says plan benefits must begin the day after your termination. If that was the case, that would be simple to say in the plan. The plan would say retirement benefits begin the day after termination. The plan doesn't say that. The plan has many provisions that are contrary to that. So, and in 7.6, it requires an application and says no retroactive. The standard of review here is limited. Under the Davis case, the court can reject the board decision only if a reasonable person would necessarily reach a different conclusion. And I don't think we've got that here. The court should defer to the decision of the board since it's based on the express language of the plan. Now, we also know the board got it right because the petitioner was invited to send his materials to the board, whatever he had for the board to consider. And he did that on July 22, and that's in the record at 335. And what's significant at that, it's his statement of position. He relies on 7.5, 7.6. Doesn't mention a word about 7.7, doesn't mention a word about by operation of the plan. We know what applies here. And the board relied on the clear and unambiguous language of 7.6 that does not provide for retroactive benefits and denied the claim, and the Chancery Court affirmed that. The decision was not arbitrary and capricious. First, under Starlink, because the board's decision was made honestly with due consideration, the court doesn't even have to reach this argument. Starlink says, quote, if there is room for two opinions, a decision is not arbitrary or capricious if it is made honestly and upon due consideration, even though a reviewing court thinks a different conclusion might have been reached. I don't think there's any doubt that the board's decision was reasonable. Applying plain language of the plan is reasonable. But even if you reach this issue, the decision is not arbitrary and capricious. There was not a clear error of judgment. The board did not disregard the facts or the circumstances of the case, and it's supported by substantial and material evidence, as we've discussed. Now, the plan provides the board with discretion and authority to interpret the plan at section 10.3. And at section 10.5, it says, and I quote, "The pension board shall endeavor to act, whether by general rules or particular decisions, so as not to discriminate in favor of or against any person, and so as to treat all persons in similar circumstances uniformly." And that's exactly what the board did here. It had never granted retroactive benefits based on the plain language. It didn't give retroactive benefits here. So 7.6 is clear and unambiguous. It's what the board applied, and we think that should be affirmed. On the other hand, the petitioner's by operation of the plan argument fails on at least 5 points. First, it's completely inconsistent with his election back in 2016 not to receive retirement benefits. He decided back then he didn't want them. Now he's before the court saying, but give them to me anyway, even though I didn't want them back then. That's completely inconsistent. Second, as indicated earlier, it's completely inconsistent with the position statement in the materials he submitted to the board, where he relies on 7.5, 7.6, not by operation of the plan, not by section 7.7. And then by its terms, section 7.7 does not apply. What he leaves out is the first part of that says, quote, if the pension board is unable to locate the participant. There's never been any claim that we were unable to locate the participant. Section 7.7 deals with unclaimed benefit. As the record indicates at pages 269 to 272, section 7.7 deals with the required minimum distribution at age 72, when we all know, as we get closer to that, you've got to start taking your retirement benefits then. That's what the procedure, if you can't find at age 72 a participant to distribute the benefits. It has no application here. Fourth, that argument makes superfluous numerous provisions of the plan. For example, section 1.9 says there can be a written election. Why would there be a written election if by operation of the plan you get benefits automatically the day after termination? Section 1.55 says, quote, or is eligible to receive retirement benefits. There wouldn't be any need to have anybody eligible for retirement benefits if they're entitled to them automatically. And then 7.5 talks about claims for benefits, and 7.6 we've talked about requires a claim for benefits. And even what's important here, there would be no reason to have section 7.7 in the plan provision he relies on. Because again, that deals with, quote, unclaimed benefits, close quote. There can't be unclaimed benefits if benefits start the day after your termination automatically. There would be no need for any unclaimed benefits. They're always claimed. Fifth, as we've already discussed, his reliance on the Internal Revenue Code and the regulation is misplaced because they both say you can require an election for benefits to begin. So all in all, nothing shows the decision was arbitrary and capricious. Nothing in the plan supports the claim that benefits begin automatically upon termination. I do want to address the forfeiture argument because only the petitioner calls it a forfeiture. The board didn't find a forfeiture, the Chancery Court didn't find a forfeiture, and there was no forfeiture. As was discussed, the only question is when benefits begin, and that's on the record at 253. It's not a forfeiture, it's just a question of when benefits begin. And as Judge McKee indicated, it's like Social Security. The longer you wait, the higher benefits you will have. And again, that's at 253 of the record. So there was no forfeiture. There was no, by operation of the plan, the board's decision was not arbitrary and capricious. Now, the petitioner also states that you should construe the plan in favor of the petitioner. You can't construe the plan in direct opposition to plain language. For example, he mentioned the Long case. The Long case expressly noted it was dealing with an ambiguous provision that was not defined in the plan. That's not the case we have here. Section 7.6 is plain and unambiguous when it says you must elect and no retroactive benefits will be paid. Again, under section 10.5, we have the obligation to treat participants uniformly, treat everybody the same in similar circumstances. Section 13.9 talks about that. It says the division through the pension board shall administer the plan in a uniform and consistent manner with respect to all participants and beneficiaries, and shall not permit discrimination in favor of any employee. Given the unambiguous language of the plan, given that the plan has been interpreted this way for years uniformly, there is no room to interpret this plan contrary to its expressed terms. The board's decision, as I've indicated, was supported by substantial and material evidence. In fact, it was undisputed evidence. Now, as far as the procedure, the constitutional issues he raised, kind of a scattershot thing, I could just go through them in the order I've got them. One, the board's decision was not in excess of its powers. Section 10.3 of the plan gives the board the power to construe the plan and to determine all questions that arise thereunder. As far as the Internal Revenue Code, we've already talked. It allows the plan to require election. Petitioner made the argument that Mr. Carney made the decisions. First, that was not raised below. He says Carney told the board what to do. That's not correct. Sections at page 704, Mr. Carney told the board it could uphold or rule differently than the pension department. The department and the plan and the benefit committee made the decisions, not Mr. Carney. That's at 708 of the plan. He complains he was limited to 20 minutes of oral argument. He was notified of that a month before the meeting, never complained, never said he needed more time. That was not raised below. He said no witnesses, no discovery, no examination of witnesses, not raised below. He had the opportunity to present whatever he wanted. He never said he had any more evidence to present. He never said he needed to examine anybody. A violation of open records. Again, the record reflects that the deliberations were open to the public and he received a transcript. He did have an unbiased and neutral decision maker, doesn't claim otherwise. The board decision was not an adversarial proceeding. It was not prosecutorial. Mr. Carney was not acting as a prosecutor. So the Marsh case he relies on has no application. So the procedure was fine. Finally, prejudgment interest, he asked for that. He gave the board nor the Chancery Court any factual basis to award prejudgment interest. There's no finding, no monthly amount, no period, no percentage sought. And in fact, it took months for the lawyers to figure out what the benefits were that he was going to be paid. Attorney's fees, finally, the court found he wasn't the prevailing party. The respondents were, and he does not attack that. And with that, Your Honor, I think we should affirm the Chancery Court and the board. Thank you.
Thank you.
Thank you, Your Honor. So briefly responding, first off, the statement about what the language of 7.6 said, that there be no retroactive benefits, that's actually not what it says. It uses an undefined term. It says, no claim against the fund for any retroactive payment by reason of the failure of the participant or beneficiary to properly or timely apply for benefits under the plan. The term retroactive payment is not defined. It's just like the undefined term that's in the Long case. There is no definition of that term, and it's not the term benefits. So our argument on 7.6 is, again, that the benefits arise under the Internal Revenue Code and the terms of the plan. And it is still the law in Tennessee that pension plans are construed in favor of the applicant. That hasn't been changed yet by the Long case in the Supreme Court. We don't know what they're going to do. It's been the law since 1944 in the Collins case. It's about 80 years, and some of us hope that'll continue to be the law. But it's currently the law that the plan is construed in favor of the beneficiary seeking the benefits. And what I've pointed you to are terms that show the claims arise under the terms of the agreement. That's the point of the definition of the benefit commencement date. It has the application track and the other track. And then you have 7.7. If you just read it, the name of it is unclaimed benefits from Article 6. That's what my client has, right? And it doesn't forfeit those. So we have the 7.7 language that carves out from 7.6, because remember, 7.6 has a gigantic condition that we say is not met, And it's arbitrary and capricious to ignore 7.7 and to ignore the other language, the benefit commencement date, the mandatory payment in 6.1A1 that meets the standards for the Internal Revenue Code. Now, the business about an election, my client didn't make an election. The reg that I attach actually explains what an election has to be. It has to be in writing, and there's all these terms you have to comply with to have an election. My client just didn't apply. He didn't know his rights. He didn't have the plan. He never got the plan until after he filed, actually both applications. We got the plan document from Mr. Carney after we filed the second application. That's the first time we were able to read the document Mr. Carney was looking at. So our argument just is, it arises under the terms of the plan itself, the Internal Revenue Code. 7.6 doesn't apply. And I've laid that out. I know it's perhaps there's a lot of sites, but it's in the plan, and I give those in my brief. So what we ask is that the court construe this in my client's favor, and consider that the board's decision using one sentence in 7.6 to wipe out my client's rights, including his right to non-forfeitable benefits, non-forfeitable, it just wipes all that out, that is arbitrary and capricious, but applying what's currently the standard, he should win on that. Thank you, Your Honor.
Thank you. Thank you both. Would you call the next case, please?
State of Tennessee, ex rel. Marlene I.